So, Ben, we're back.
We're back.
We're back. This time on the impact of COVID on upcoming opposed renewals. Now, I've been thinking about whether these trials can be effective at the moment. Because for starters, it looks like the FTT is barely hearing any of these matters. So if you're already in the pilot scheme for Central London cases, the chances are your hearing won't be going ahead anytime soon. But if you're issuing at the moment, then what I do know is that Central London County Court have been processing the claims in judicial boxwork, although, again, whether you'll receive any order from the court anytime soon is frankly anyone's guess.
Yeah, we're hearing from Central London that it's got decent availability of judges, but the court staff are stretched to breaking point. So something to keep tabs on. I mean, I guess if clients are worried, they might try and book an appointment with the Central London Chancery user surgeries, which take place from time to time.
Yeah, that's a good idea. Absolutely. I mean, but for those matters that are sort of already in the court list, it seems to me there's a key substantive issue here too, when rent is in dispute in the unopposed. I mean, I was kind of reflecting on the question of how can the courts properly assess the rent payable under the new tenancy at the moment? And I know the issues cropped up in one recent case in central London where a retail landlord sought an adjournment of a trial on the basis the court couldn't properly determine rent at the moment, given that the market is far too uncertain, etc., etc.
Yeah, I mean, one initial way of looking at this is just to say, well, sometimes courts are faced with difficult problems and they just have to do the best on the best evidence that's available to them. You know, sometimes courts have to predict what kind of capital sum is needed to give a future annuity or something like that. They've just got to deal with the unknown and they have to get on with it. Or in valuation cases, sometimes you get really tricky problems when you've got a unique property and there just aren't any comparables available. Does that mean that the court says, oh, well, I can't possibly decide this? No, the court just has to get on with it and do the best that it can, and the experts will just have to exercise their valuation judgment and assist the court as far as they can.
Well, I mean, that's certainly one way to look at it, and I wouldn't be surprised if, you know, parties or indeed the judge, you know, raise that sort of issue. But just kind of reflecting on that for a little bit and testing it, valuation judgment based on what? Because I mean, on one analysis, there's no evidence or proper basis on which to determine the rent. I mean, just to kind of test that idea, starting point is that the court, as you know, is to determine the rent which the holding might reasonably be expected to be let for by a willing lessor, willing lessee in the market, and then the valuation date is in 3 months, 21 days time, the date of commencement. And that value is assessed having regard to the terms of the new tenancy, as well as being subject to the usual statutory disregards. Now, as you've already identified, expert valuers invariably assess that value on the comparable method, so based on comparable transactions for similar properties in the current market. Now, in the ordinary case, ordinary times, the court's going to have the best available comps. They might not be perfect, but the best available ones, and the expert's view on them. And the uncertainty about how the market might change in the kind of 3 month, 21 day period from judgment is simply dealt with by making an express assumption as to whether the market is likely to change on that period based on the actual evidence as to whether you're in a rising, falling, or stable market. But we're in a different situation here. Where are the comps which show that a willing lessor and lessee would what they would negotiate in a COVID market, particularly for retail and hospitality, where the businesses are mainly closed? And frankly, who knows what the market's going to look like in almost 4 months' time? I mean, I'm not a valuer, but it's hard to see how even a valuer could say, because no one knows whether it's going to be business as usual by then. So what's the court do? Does it assess the rent on the basis that no one knows? That seems to me pretty unsatisfactory if that's the way that the court's going to have to approach it.
I've just had this image of you standing up in court, banging the table, saying, "Show me the comps." No, I can see it's really difficult. It's really difficult. I mean, you might find that either party on that basis might apply for an adjournment.
Yeah.
But even if they can persuade the court that the difficulty of valuation in and of itself is a reason for an adjournment, there's a further problem, which is, well, how long do you adjourn for? because we don't have our crystal ball. We don't know how long it's going to take the market to settle down. So there's a real difficulty there.
Yeah, I mean, definitely something that I would expect to be raised by somebody. And another point is that in reality, tenants may well oppose the adjournment because typically they're going to want the trial to come on as quickly as possible for sort of probably two main reasons. The first is that they're stuck paying the passing rent under the current tenancy for the period of the adjournment, and that's going to be higher than the new rent if the market is falling. And the second is that, the application for interim rent isn't going to help them. So that's going to act as a further motivating factor. It's not going to help them because the interim rent is likely to be higher than the final rent in a falling market because of the way it's assessed.
Yeah, I mean, you can see, just throwing into this mix then of an adjournment and those issues, of course, there are other reasons for an adjournment. You've got your usual bucket of COVID-19 related reasons.
Yeah.
Can the court even just accommodate a trial like this right now? Are there sufficient Skype facilities available? I mean, in these sorts of cases in particular, there might be a need for a site visit, which could be important because that's obviously not practical at the moment. But also, there's another important point for cases, unopposed cases, which are actually in the pipeline at the moment, which is if you've got your trial in the near future, is there enough time for the parties to produce supplemental evidence on the new rental market, consider that supplemental evidence, deal with joint statements, etc., and still prepare for trial? And you might find that your trial estimate is longer as well now because of the additional complexities this all causes, and that in and of itself might be a reason to adjourn. But of course, then you've got a problem, which is that even if the parties are agreed on an adjournment, what do they do whilst the court is still determining that application? Because it's taking the courts an age to deal with these applications. You might find it's only dealt with a couple of days before trial. And what should you do meanwhile? I mean, the parties can charge ahead and prepare for trial, hoping that it's not going to go ahead. But that could waste a huge amount of costs because all of that supplemental evidence is going to be superseded when you come to the adjourned trial. Another way of dealing with it is to get the parties expressly to agree to an adjournment, even if the court hasn't yet approved it, because the guidance that we're getting from the courts is that that is a powerful factor in favour of adjournment, and hopefully everything would be okay.
Yeah, I mean, I can see all of those things. So, I mean, inevitably, applications to adjourn are going to throw up issues. And I suppose from the perspective of someone who's trying to put the trial off, if they can find the kind of issues that you're identifying, then that's going to be a potential boon to them. But what if the trial does actually have to go ahead? I mean, if you're for the landlord, what you don't want is for the court to determine an unacceptably low rent on the basis that, the market's uncertain and we end up with the kind of assessment I was alluding to earlier. Particularly in a retail case, the judge might decide to apply a discount on the basis that, the shop premises, retail premises are closed now, and it's uncertain whether they will, open in the future. Now, if the court were to make that kind of assessment and you end up with your determination as landlord being unacceptably low, not only is that going to reduce your income stream for the holding, but also your other tenants might actually latch on to that determination in negotiations for their renewals further down the line. So it may have a sort of a knock-on effect in relation to other parts of your premises as landlord. So if you're landlord heading to trial, then possibly a way to deal with at least some of the kind of issues that we've been identifying is to introduce a term in the new lease that the tenant will not pay rent if the business cannot open owing to COVID-19. You then invite the judge to assess the headline rent on the premise that the shop is open, which means that the headline rent is going to be determined on a, broadly speaking, more normalised basis.
Yeah, that's a really interesting idea. Yeah. Well, look, I mean, it's going to be interesting to see how these issues play out over the coming months.
Yeah.
Meanwhile, I'm looking forward to seeing you at next week's roundtable discussion dealing with some of these very issues.
Absolutely. Looking forward to it too. I'll see you then. Bye, Ben.
Bye.